Good evening, ladies and gentlemen, and welcome to what is now the 15th Lord Rueff Lecture. And I must say, the setting for this particular lecture is magnificent. I think probably one of the best ones we've had so far. My name is David Altras. I am... Can you all hear me?
That's better.
I'm not used to using a microphone. But I'm in court, when I was in court, it was just a question of speaking loudly until some disagreeable judge would say to you, "I'm sorry, I can't hear you." That didn't mean that he couldn't hear you, it just meant you were sitting in the wrong place. I am chair of the legal group of the British Friends of Neve Shalom Wahad El Salam, the Oasis of Peace, also known as the Village. This lecture and the 14 preceding lectures are named for Lord Rueff, who was the chair of the legal group, a very enthusiastic chair as well, of the legal group until his untimely death in the autumn of 2009. Since that date, we have tried to hold an annual lecture to commemorate his great contribution that he made to this charity. I'm pleased to say, I hope I can say, that his sister Catherine, I don't think she's here yet, is, if she's not here now, she will be, and his brother-in-law, Professor Roy Good, is also due to join us. Before I have the pleasure of introducing our distinguished speaker, David Neuberger, there's one thing I want to say. David is not, in fact, the first former president of the Supreme Court to address this charity. That accolade goes to a former president, Brenda Hale. You may remember that she spoke about 2 years ago. So she and David joined the eminent list of speakers who have volunteered to address this charity. They include Professor Philippe Sands, King's Counsel, Baroness Julia Neuberger, Simon Sharp, Professor Sir Lawrence Friedman, and Bishop Rose Hudson Wilkin, to name but a few. As in previous years, I have to pay full tribute to our generous sponsors, Mishkan and Rea. Our sincere thanks go to them. I must also thank our second sponsor, Jewish News. Can I, in addition, thank Monsignor Roland, in whose magnificent church we are holding tonight's event, and I hope that you will be able to join us for future events. He did express some interest in doing so. We also welcome Samar Salame, co-director of the Village, who is currently completing a year's scholarship at SELS in London, and there she is over there. Next, the village itself. The village lies about 40 kilometers to the west of Jerusalem. There, some 90 families of Israeli Jews and Israeli Palestinians live together. I am told that there are a further 50 families waiting for their houses to be built, and another 80 are. Welcome, Mr. Justice Stephen Morris. I'm told that there are another 80 families waiting for the village to acquire additional land. There is also, and this is very important because this is what this charity tends to support, there is also a nursery, kindergarten and primary school in the village where Palestinian and Jewish children, numbering about 200 in all, attend in roughly equal numbers, coming from the village itself and from the outlying communities. The school is bilingual, The pupils are taught in Hebrew and in Arabic. It is maybe of some interest that the second language in Israel is not Arabic, despite the fact that Israel sits in a sea of Arabic-speaking nations. The second language in Israel is English. I will leave it to you to decide whether it's appropriate in those circumstances for the two languages, the two main languages in Israel, to be English and Hebrew rather than English and Arabic. Anyway, the children's taught both in Hebrew and in Arabic. So the school, the primary school, provides a unique opportunity for children to learn together, to play together, and to form friendships. And this allows them to accept each other as human beings, not as one of the others. The village also has a school for peace where Jewish and Palestinian participants of all ages formally meet to explore their respective national, cultural and ethnic identities with the help of trained Jewish and Arab facilitators. It is some pride that over the years, tens of thousands of Jews and Palestinians have taken part in the workshop and the courses. Now, at a time when news from the Middle East is universally grim and appallingly depressing, you'll agree with me, notwithstanding very tentative steps towards peace in Gaza, in my view, the village stands as a beacon of hope and an example of peaceful coexistence. Regrettably, there have been problems with the extremists from both sides and from the Israeli government, as you'll hear about it later on. Not so long ago, there was a settler arson attack on the village when buildings were destroyed by fire and the words "death to Arabs" were spray painted on the walls of the primary school. The present turmoil in the Middle East has, of course, resulted in severe tensions, disagreements, and problems between the two resident communities. They are doing their best to resolve their differences through talking openly with each other and through intercommunal meetings and the like. And that, too, is an example for the rest of the region in how to deal with disagreements. Well, now, it gives me great pleasure to introduce and welcome our guest speaker. David Neuberger comes from a distinguished medical family. After Oxford, where he studied chemistry and a short spell in a merchant bank, he was called to the bar in 1975. He was a pupil of Ronnie Bernstein, Queen's Counsel, and he was a member of, and subsequently head of, Falcon Chambers, property law specialists. Thereafter, I have to say that his rise in the law was nothing short of stellar. Silk, High Court, bench, sitting in the Chancery Division, Lord Justice of Appeal, Master of the Rolls, and finally, in 2012, President of the United Kingdom Supreme Court, a position from which he retired in 2017. He now practices as an arbitrator from One Essex Court and is a non-permanent judge at the Hong Kong Court of Final Appeal. His talk, with one eye on that notorious Daily Mail headline, is entitled Independent Judges, Friends, Not Enemies of the People. David Neuberger.
Thank you very much indeed. Please say if you can't hear me, because one often talks thinking one is perfectly audible, and at the back one isn't. So don't hesitate to say if you can't hear me, although if you can't hear me, you don't know I've just told you to tell me that you can't hear me. In the 21st century Western world, there are few people who would quarrel with the notion that a civilized state should be run in accordance with the rule of law. But I think the rule of law is an expression which can have different meanings to different people. I suggest it's got two principal meanings. The more basic meaning is essentially concerned with how a society is run. It involves a society run in accordance with laws, in contrast with societies which are anarchic or run by arbitrary decisions of dictators. The more substantive and more often discussed type of the rule of law is concerned with the contents of the law, and particularly with fundamental individual rights, or human rights as we call them. Now, the more basic concept, rule of law, the state being run in accordance with the law, has certain basic requirements. First, the laws which impose rights and duties must be accessible and comprehensible. People have to know what their rights and obligations under the law actually are, otherwise you don't have the rule of law. Secondly, the laws have to apply to everybody equally, the rich and powerful, companies and individuals, the government, people in government. Thirdly, the laws must be enforceable by those with rights and effectively enforced against those who break the law. Now, effective enforcement carries with it a need not only for an effective police force, of course, but it means that we need courts with judges who are independent, impartial, and competent, and whose processes are efficient and open, and whose decisions are respected and enforced, and to whom everyone with rights has access, and before whom people who break the law can be brought and dealt with. If people have rights, but they don't have access to the courts to enforce their rights, then they don't really have the rule of law. And if people see the law being flouted without redress, then the rule of law is a hollow shell. And the areas where judges are asked to decide disputes are multifarious. The role of criminal courts is, of course, fundamental to law and order. Unless criminals are caught, prosecuted, and punished, not merely does public faith in government wither away, but society quickly breaks down. But the rule of law does require that those accused, even those convicted of crimes, should be treated appropriately, to have a fair trial as soon as possible, to have legal representation and advice, to have the benefit of the presumption of innocence, and to receive no more than appropriate punishment and a genuine opportunity to be rehabilitated. And rehabilitation is not merely humane, it benefits society as much as the individual, as it reduces the prospects of recidivism. But judges, of course, don't merely have to try criminal cases. They have to try a myriad of different types of civil claim. Claims by individuals involved in accidents, employment issues, social security claims, residential, commercial, and agricultural property-related claims, and commercial cases, to name but some. Without the courts, all these claims would likely go either uncompensated or would be determined through violence or corruption. Not only are the courts needed to ensure a civilized and fair society, they're also needed to ensure the economy doesn't wither, as businesses won't invest in a country where they cannot be confident that their rights and contracts will be respected and enforced. And judges, of course, also have a vital part in dealing with family disputes, sorting out financial arrangements between divorcing couples, and even more importantly, protecting children. And then, of course, there's the vital function of protecting everyone against unlawful or irrational acts and decisions of the state. In a world where the power of government is getting ever greater and the law is becoming more and more complex and extensive, the risk of executive overreach is on the increase, and the role of the courts in public law is more important than it ever was. The fact that we live in a world where the law is increasingly complex gives rise to another important feature of the basic rule of law. Individuals and companies and everyone should have access to independent, properly trained lawyers. It's an ever more essential ingredient of the rule of law that legal experts are there to advise and speak for individuals and companies and to assist the judges when it comes to identifying, interpreting, and applying the laws. If access to lawyers for advice or for representation in court is restricted to the rich or the few, you don't really have the rule of law. That's the basic rule of law. The second more ambitious version of the rule of law takes these requirements of the first type of rule of law for granted. It effectively involves the state, according to its citizens, all the sorts of rights which are to be found in the European Convention on the Fundamental Human Rights and Freedoms. And there are similar other human rights treaties across the world. Freedom from torture, from arbitrary imprisonment, freedom of expression, freedom of religion, freedom of assembly, the right to privacy, the right to family life, freedom to go to court, freedom to marry, freedom to vote, but not, in my view, the freedom to bear arms. These rights are the subject of Lord Bingham's famous book, The Rule of Law. And this aspect of the law, I think, can be summarized in a fundamental principle, namely that while the rights and interests of society as a whole require individual rights of self-determination and self-expression to be curtailed, the curtailment should be kept to a reasonable minimum. Now, both aspects of the rule of law are embodied, I suggest, in Neve Shalom, Wahat al-Salam, Oasis of Peace. It's fundamental to the whole concept of Neve Shalom, Wahat al-Salam, that everyone, whatever their religion or ethnic origin, is entitled to the same rights as everyone else, that they should live in accordance with the rule of law, in peace, with respect for the rights of others, and entitled to respect from others for their rights. Reverting now to the rights accorded under the Human Rights Convention and other similar rights, there's much discussion and controversy about the effect of some of these rights, including whether UK judges are too involved in deciding human rights cases, and even whether the UK should remain in the European Convention. As to that latter issue, it may be a cheap point, but I would suggest that much is revealed about you by the company you keep. And if we left the European Convention, we would be joining Russia and Belarus, which are currently the only two European countries which are not parties to the Convention. But more relevantly for this evening, judges have to be involved in deciding the contents of a human right and whether in a particular case it's been infringed. It's no good giving people rights if they can't enforce them, as I've said, and the only effective way rights can be understood, interpreted, and enforced is by independent tribunals. It would be a travesty if the government decided such cases, because most human rights claims are brought against the government. And at least in the UK, if politicians don't like the way judges are developing the law, politicians can change the law through Parliament. The vital public law and human rights law function of judging highlights the importance of judges being independent of the government. This independence is enshrined in the doctrine of separation of powers, which is generally associated with the 18th century French political philosopher Charles Baron Montesquieu. He identified three branches of government: the legislature, which, as he put it, enacts temporary or perpetual laws and amends or abrogates laws that have already been enacted, i.e., in our system, Parliament. The executive, which, as he put it, makes peace and war and establishes public security, and I add, in these days of much greater government power, gives effect to the laws generally: ministers, civil servants, local authorities. And then thirdly, the judiciary, which interprets the law and, as Montesquieu put it, punishes criminals and determines disputes that arise between individuals, and these days, importantly, disputes between individuals and the government. Montesquieu explained that there can be no liberty, as he put it, if the legislative and executive powers are united in the same person. He also said that there's no liberty if the judiciary power is not separated for the legislative and the executive. The two UK court cases brought by the redoubtable Gina Miller in the preceding decade provide vivid examples of the separation of powers and the function of the three branches of government. When in 2017, Mrs. May's cabinet decided to withdraw the UK formally from the EU by serving a so-called Article 50 notice, Mrs. Miller challenged this by seeking a ruling from the courts that the cabinet which is the executive part of government, could not do this without formal authority from Parliament, the legislature. The Cabinet argued against her that leaving the EU was a classic decision for the executive, because it's up to the executive, the Cabinet, the Prime Minister, whether to make peace or war, whether to enter into treaties or leave treaties. That is a matter for the executive. Mrs. Miller accepted that that was the general rule, but she said that leaving the EU automatically involved changing the laws of the UK internally, and changing the law could only be done by Parliament or with the formal authority of Parliament. The issue came before the UK Supreme Court, who decided that Mrs. Miller was right. A decision which, to be fair, the executive accepted. They took the decision to leave the EU to Parliament, and Parliament voted in favour of them being able to do so. And there was a statute recording that. This was a classic case of the judges performing a vital constitutional function, deciding on the boundary between the functions of the executive and the legislature, and giving us the opportunity in a judgment to explain the reasons for that. And because the Supreme Court is filmed, people could watch the argument develop and see it was developed in a civilized, careful, legal way. 2 years later, the next Prime Minister, Mr. Johnson, decided to advise Her Majesty the late Queen to prorogue Parliament. In other words, temporarily to suspend Parliament, which she then did, quite rightly, because the monarch is constitutionally expected to follow the Prime Minister's advice. Mrs. Miller took the decision to court and sought to have it quashed. She argued that first, it was argued against her that first, the monarch's decision could not be reviewed by the courts. The Queen was above the courts. And secondly, anyway, it was wrong to get judges involved in deciding the legalities of what goes on in Parliament. Again, Mrs. Miller won. Although the courts accepted that the Queen was immune from court decisions, the Supreme Court held that the advice she got from the Prime Minister was not above the law, and if that advice was unlawful, the consequential decision, the decision to prorogue Parliament, could be quashed. And the judges said they were not getting involved in a parliamentary decision, but a decision made outside Parliament, but implemented in the House of Commons. As no reason was given by Mr. Johnson for the unusually long period of prorogation, the court held that on the facts, his advice to the monarch was unlawful. Again, to give credit to the government, Parliament was recalled, the court's order was obeyed. That decision remains controversial in some quarters. It was after I'd retired, so I can say it was plainly right. If the Prime Minister advised the Queen to prorogue Parliament for a year, the only way in which Parliament could be brought back would be through a decision of the court. Parliament couldn't do it because it would have been prorogued, and the executive couldn't do it because they had decided that Parliament should be prorogued. Now, the court's decisions in the two Miller cases were also attacked in some quarters as being undemocratic. Frankly, a fatuous assertion, because in each case, the decision backed the democratically elected Parliament against the unelected Prime Minister and Cabinet. Of course, the Prime Minister and Cabinet members are elected, but they're elected as MPs, and that's how they are democratically accountable. They are not elected as Prime Minister and ministers. Thus, reverting to Montesquieu, he was writing at a crucial time. His influence quickly became apparent within a few decades as the United States was founded with a constitution which pretty faithfully reflected his basic principles. So in the US, there's a clear separation of powers between the lawmaking legislature, that's Congress, the Senate and the House of Representatives, and the executive, which is presided over by the president. If the president wants a member of the Senate to be in his cabinet, the member must leave the Senate. Laws made by the legislature can be vetoed by the president, but his veto can be overridden by a 2/3 majority. The president has lawmaking powers. The third branch of the government, the judiciary, is also quite separate. A fundamental feature of the US is that it has a constitution which is interpreted by the courts and which enables the US Supreme Court to strike down laws which do not comply with the Constitution, or to be strictly accurate, which do not comply with the Supreme Court's interpretation of the Constitution. This power was one which the US Supreme Court decided that it had in 1803. And given that the US Constitution can only be changed by a 2/3 majority of Congress or state legislatures, which it would be very difficult to achieve, this means that the US Supreme Court has a lot of political power. Thus, whatever you think of the famous case of Roe and Wade, it can be said to have been quite a stretch to conclude that the 14th Amendment to the Constitution, which says that a state should not deprive any person of life, liberty, or property without due process of law, gave women the right to an abortion, or that the right to keep and bear arms in the Second Amendment should apply to what the Supreme Court referred to as all instruments that constitute bearable arms, even those that were not in existence at the time of the founding of the United States. Now, the position in the United Kingdom is very different. Institutionally, we have fairly clear demarcations between the three arms of government, the legislature, the executive, and the judiciary. But especially at the top, there is no separation of powers between the executive and the legislature. The heads of the various parts of the executive, ministries, and government ministers, including the head of the executive, the Prime Minister, are all in Parliament, and all your senior ones in the House of Commons. So there is no separation of powers at the top in this country between the executive and the legislature. On the other hand, the judiciary is quite separate from the executive and the legislature. No judge could be an MP or a civil servant while he or she was serving as a judge. And unlike the US, indeed unlike almost every other democratic country, we in the UK do not have a coherent constitution. What we do have is a collection of conventions and sort of constitutional statutes, all of which can be freely repealed and amended by Parliament like any other law. It's a sort of make-it-up-as-you-go-along constitutional system, ending up with things that largely work, although no sane person would propose them. The House of Lords is a good example. People talk about Magna Carta as having some special status, but it was a deal between an inept king and his barons, and it was repudiated by the king within weeks. And of its 61 provisions, only 4 still survive. Indeed, until well into this century, we didn't, at least in theory, even have a fully independent judiciary. Our top judges, the law lords, sat not as a court, but as a parliamentary committee. And our top judge, the Lord Chancellor, was a government minister. In many respects, we were and are run by conventions, rules which are accepted but not enshrined anywhere. One of those conventions is parliamentary supremacy, which means that unlike in the US, if the Parliament passes a statute, the courts cannot strike it down, however inappropriate the judges think it is. The furthest the UK courts can go is to interpret a statute as far as it properly can with what has been called the principles of constitutionality, which some might say is a sort of classic piece of British make-it-up-as-you-go-along wriggle-room. But it means that the 2 Miller cases to which I referred, and in which the courts had to decide fundamental constitutional issues, are few and far between. It also means that when all the fundamental rights in the European Convention were brought into English law in 2000, UK judges became more concerned with deciding policy and non-party political decisions they'd been traditionally doing, because for the first time, citizens in the UK were accorded formal fundamental rights of the sort which citizens in other countries with constitutional rights have long enjoyed. In case that gives the impression that until 2000 British people had no rights, that would be wrong. We'd proceeded on a typically insouciant or confident way, yet effectively assuming that the sort of rights enshrined in the European Convention were enjoyed by everyone as a matter of course. But when you have rights assumed as a matter of course rather than spelt out in a statute, it's much more difficult for the courts to spell out exactly what those rights are and to define them and enforce them in court. Now, the Israeli constitutional system has features of both the US and the UK systems. Together with New Zealand and the UK, Israel is one of the 3 significant democratic countries without a formal written constitution. And the Knesset, the Israeli parliament, introduced a set of fundamental rights under the title The Basic Law in 1992. Again, rather like the UK, in that the Basic Law, like the Human Rights Act, introduced fundamental rights into the Israeli legal system. But unlike in the UK, and more like the US 200 years earlier, the Israeli Supreme Court held, in a series of decisions, that it had power to strike down statutes enacted by the Knesset if the court considered that they infringed the Basic Law. And like the US Supreme Court, and some might say like the European Strasbourg Court, the Israeli Supreme Court took a relatively expansionist view of the extent of the rights granted by the Basic Law. The fact that judges in the USA and Israel can invalidate legislation enacted by a democratically elected legislature means that they are constitutionally more powerful than judges in the UK who have no such power. If you are committed to a universalist democracy, and a fortiori if you are a populist, the notion that democratically unaccountable judges can veto legislation enacted by a democratically elected legislature may seem offensive. But if you're very skeptical of concentrating power in 1 or 2 institutions, then diluting the tyranny of the majority through judicial override has obvious attraction. So each of the 2 types of system has its advantages and drawbacks. Provided that judges in the US-Israeli type system exercise suitable self-restraint, bearing in mind that their non-elected status, and provided that judges in a UK type system are appropriately imaginative, there may not be as much different in outcome as the difference in powers appears to suggest. But it does seem to me that particularly in these moderately turbulent times, there is much to be said for the UK model. What it does achieve is effectively to take the judiciary out of politics, and therefore to take politics out of the judiciary. Because the US Supreme Court has significant political power, appointments to the court are political, and in recent years they've become highly political, often highly charged political affairs, with candidates being selected and opposed by reference to their political and social views, and then, with relatively few exceptions, giving judgments on controversial issues along predictable lines. The fact that US Supreme Court justices are appointed by the President, who is by definition a party political figure, with the sanction of the Senate, a collection of party political figures, represents quite a contrast with the UK system, where judges are appointed and promoted by a panel consisting of 7 judges and lawyers and 8 lay people, but no serving politicians. While any appointment or promotion has to be approved by the Prime Minister or the Minister of Justice, that is almost always automatic. And anyway, all that can be done is to send the decision back for reconsideration. When I was a judge, I had little idea which way the great majority of my colleagues voted in general elections. And quite often, when we discussed the topic, I found myself surprised what some of my colleagues revealed. I don't think I would have had that difficulty if I'd been in the US Supreme Court. It's fair to say that the US Supreme Court justices are as independent as the UK Supreme Court judges when it comes But when it comes to political and social issues, not only may their decisions be predictable, but more worryingly, at least to me, they are there because their decisions are more predictable. This almost inevitably means that the court in the US is perceived at times as a branch of the political system with the judges wearing party badges, rather than as genuinely attached judiciary figures with apolitical judges. This is not only a road to bad judging, in my view, but a road to loss of public confidence. The relatively apolitical US Supreme Court enjoyed 70% public confidence 20 years ago. Today, public confidence in the far more political court is below 50%. By contrast, 68% of the UK public trusted judges 20 years ago. Today, the figure is higher, 73%, not only because I resigned. Of course, in the US, it's not just Supreme Court judges who are appointed through politicians. It's true of the federal bench generally. It's also true of many of the state judges. But in many states, judges are democratically elected, which inevitably gives them also a political character, albeit for different reasons. The combination of politically appointed judges and the judge's constitutional role in the United States can lead to toxic results. The attempts to undermine President Trump following the 2020 election, and now his attacks on his former opponents, were and are carried out through the justice system. The prosecution of politicians through the courts is particularly unfortunate in a country which suffers from politicization of judicial appointments. In every politically related US case, almost the first question to be asked is the judge a Democrat or Republican appointee? And alas, all too often the answer to the question is pretty clear from the way the case is conducted. This is scarcely likely to encourage respect for the law. Judges should be kept out of politics, as I say, and by contrast, when we had a problematic Prime Minister, Mr. Johnson, he was effectively removed from office, not by a judge, but by a parliamentary committee. The courts were kept out of what was a political exercise. This raises another thought. I was brought up to believe that the US system, with its famous checks and balances and genuine separation of powers between the executive and legislature, was enviably better than our haphazard system. But recent experience suggests otherwise. Because of the separation of powers in the US, the president and cabinet members are not routinely answerable to Congress. They don't have to turn up. Here, prime ministers and cabinet members have to account for their actions in the House of Commons on a weekly, even a daily basis. And executive action of the sort we are seeing from the current US government, without any legislative oversight, would, for the same reason, be unthinkable in the UK, because the Prime Minister would have to account for himself or herself in Parliament. Meanwhile, in Israel, where the judges have been exercising not dissimilar constitutional powers to US judges, there's been something of a collision course between the government and the Israeli Supreme Court for the past 3 years. Judges are selected and promoted by a 9-person committee, of whom 4 are serving politicians, 3 are judges and 2 are lawyers. In early 2023, the Minister of Justice came up with proposals in the Israeli parliament, which included 1, replacing the appointment committee, so it had 11 members, of whom 7 were politicians. 2, permitting the Knesset to override any judicial decision which struck down legislation. And 3, removing the right to judicial review in a case where the only ground of attack was irrationality. Now, on the second issue, permitting the Knesset to override a decision of the courts, it's hard for a UK lawyer to get too excited about that. Our courts have never had the power to strike down legislation. Parliament's always had the power to override a court decision. Nonetheless, whenever the executive or legislature is seeking to cut down the power of judges, there should be alarm bells ringing. The Israeli government proposal to recast the Judicial Appointments Panel is, in my view, highly objectionable and would lead to very undesirable consequences. It would seem that the proposal would not merely mean that a majority of politicians would be on the committee that appoints judges, but it could easily be orchestrated so that there was a majority of government members on the panel. The proposal almost seems guaranteed to ensure that every judge will be seen as committed to the party in power, which will inevitably undermine public faith in the judiciary and indeed effectively undermines the independence of the judiciary. Yet in March this year, I regret to say, the Knesset passed a statute giving effect to this change. The third feature I mentioned, raising the hurdle for judicial review, i.e. for challenging government decisions and actions, by removing irrationality as a ground of challenge, in my view is equally objectionable. It deprives citizens of a very valuable protection against an overmighty government. Indeed, I think it involves seriously undermining one of the most important functions of the judges, namely to protect citizens against arbitrary decisions and actions of the executive in a world where there are an increasing number of executive actions and decisions which affect all our lives. I'm afraid the Knesset enacted the law relating to irrationality in September 2023, but consistent with the collision course, 4 months later, the Israeli Supreme Court struck down the legislation as infringing the basic law. We have to watch this space. I think that the argument that irrationality, which is the ground which they said could no longer be raised as an objection to a government decision, was said to be a personal subjective decision and therefore should not be left to judges. But when you look at the judgments in this area deciding what's irrational, judges have developed a very clear and principled test. I think it's important to look at that because it demonstrates a vital aspect of the judge's function. It is to analyze things as objectively, as logically, and as transparently as possible. And that is why in this country it is good to see cameras in court, which some of my more conservative colleagues opposed. People can see the law in action. People can see that legal argument is developed in a logical, principled way. Legal arguments can seem bloodless and boring, but for that very reason, they provide a valuable counterweight to the rough and tumble of political arguments. Parliament and the courts are both an essential part of the way we're governed, and the fact they sometimes cross each other is not only inevitable, but it's welcome. But while they can cross each other and disagree, it's important that they respect each other's functions and don't let their disagreements become personal or lead to insults or worse. The judges have a duty to exercise a degree of self-restraint, bearing in mind that they are not democratically elected and that they are effectively irremovable, so long as they behave themselves. And they should not be oversensitive. Politicians and the press have every right to express disagreement with a judge's decision, and to do so in strong terms. But politicians and the press should not attack judges personally or suggest inappropriate motives just because they don't like the judge's decision or reasoning. It should be remembered that the judiciary is particularly vulnerable. Alexander Hamilton famously observed in the period leading up to American independence and discussing the Constitution of America, that judges have no influence over either the sword or the purse and can take no active resolution whatever. The judiciary may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. So attacks on the judges are highly undesirable. In this country, we're relatively lucky. The Enemies of the People headline in the Daily Mail about the judges following the first of Mrs. Miller's successes was reflective of a disturbingly similar Nazi newspaper headline some 80 years earlier. And as I've said, it was half-baked, because the judgment involved handing the decision to leave the EU to the democratically elected parliament rather than leaving it to the unelected executive. And the ministerial failure at the time to condemn it was lamentable. But in many ways, the most important point is for this country is that it was a one-off event. It's fair to add our politicians have a good, if not spotless, record of keeping off attacks on judges, and particularly when one considers what the media are capable of, the newspapers in the UK are generally not too strident when it comes to disagreeing with judges. The position is less happy in the USA and much less happy in Israel. It's regrettable that the strongest democratic country in the world and the only real democratic country in the Middle East are facing real threats to the maintenance of a healthy, respected, independent, apolitical judiciary. It threatens to weaken them morally, socially, and economically at home, and undermines their reputation and standing abroad. Albeit for very different reasons, there has rarely, if ever, been a more crucial time for the US and for Israel to show to the world, as well as to their citizens, that they are countries which respect the rule of law in general and support an independent and effective judiciary in principle. Looking in particular at judges in Israel today makes me realize how relatively calm the waters for UK judges are by comparison. It's true that our politics are more confrontational and divisive than they were, that we are seeing more attacks on judicial independence from the politicians and the media, that we have assaults on fundamental freedoms, particularly due to asylum seekers' rights. But these problems pale into insignificance when one considers the pressures on the Israeli judiciary called to rule on West Bank issues, Gaza issues, as well as the fundamental, almost existential judicial independence issues I've mentioned. Although the UK appears better off at the moment in this area, we have no idea what's coming next so far as the political future is concerned. And wherever we are, what we do know is that the price of liberty is eternal vigilance. And in these turbulent times, we've never had greater need to be vigilant, whether we're judges, lawyers, or non-lawyers, and whether we are in the United States, in Israel, or in the UK. Thank you very much.
Lord Neuberger, you mentioned that the Israeli judges would be criticised by the government for their right in the Israeli Supreme Court to decide whether or not legislation was irrational. That, of course, is in the context of a constitution where there is just one house rather than two. The British judges do not have that power. Their power under administrative law is much less than determining whether something is irrational or not. Please comment.
If I heard that right, our courts can override decisions and what's called secondary legislation if it's irrational. What we can't do is what judges can't do in this country is to override statutes if they think that statutes are irrational. To be honest, in many cases, judges can get round that by saying that they're interpreting the statute and it's unlikely that Parliament meant to do anything irrational, and therefore they will interpret the statute in a way that is not irrational. But if the statute is absolutely clear, then you can't get round it that way. If I've got the question you've asked right, that's my answer. Where in Israel, the Supreme Court has decided, like the US Supreme Court, that it can override statutes if they're irrational. I think the advantage of our system, as I've said, is that judges are largely kept out of politics because they don't have to make political decisions, or I don't mean party political, policy type decisions. They're less political, but they are less powerful. And as you say, in Israel, unlike the United States and the United Kingdom, there's just one parliament. Here we've got two houses. In America, the balance between the Senate and the House of Representatives is a more equal balance, if you like. In this country, the House of Lords is very much the junior partner. In the end, all it can do is to delay legislation. But we do have the benefit of a second house, albeit the way it's built up over the years is pretty strange. Because I'm a member of it, I'm probably biased, but on the whole it works quite well, although I think a lot could be done to make it better.
Thank you. Another question, please. I saw somebody hand up here.
Lord Neuberger, you mentioned, in your biography, you mentioned that you sit as a judge in Hong Kong. I know you've not mentioned Hong Kong, but I'm sure everyone here will be interested to know your views to what extent the judiciary in Hong Kong will remain independent as Chinese government influence becomes stronger.
I've had a fair amount of criticism in one or two places for staying as a judge in Hong Kong, and I understand the criticism. I have to be a bit careful about what I say, because when you sit as a judge in a place, you shouldn't get involved in politics, as I've indicated. So the law introduced recently, the national security law, is a law which most people in a country like this would think is extreme and interferes with human rights. You then have to make a policy decision, if you're a judge in that country, whether you find it too offensive to carry on sitting there if you don't agree with the law. As it happens, I don't decide cases concerned with national security law. Although they have what human rights lawyers would regard as that blot on their law, their judges are completely independent of the government. When I go to Hong Kong, which I'm due to do I do about every 18 months, I go for 4 weeks. I'm due to go in a week's time. If I thought that the judges were being lent on by the government in any way, I would be off like a shot. The judges do act independently and do decide cases according to the law. Outside national security law, it's not very different from this country in terms of their approach to the law. I think in this country, for understandable reasons, people are particularly upset to see, in some respects, the more oppressive regime in Hong Kong, because we had a degree of indirect responsibility for what happened there and what's happening there. To be fair, until the last minute, we didn't give it any democracy at all. We did at the last minute before we handed it back. But I have colleagues who sit as judges in Kazakhstan and Dubai, in the courts there. And with all due respect to them, if you look at the rule of law index on various bases, they do significantly less well than Hong Kong. But we have a special concern about Hong Kong, a special interest in Hong Kong, which is understandable. And I was a judge there from 2010. I've been going there every 15 months, 18 months since 2010. I've got a lot of colleagues there. I've got a lot of respect for them. And I have a certain personal loyalty towards them. And that's another reason I would stay. But as I say, I would not be prepared to be a judge in any circumstances in a system where the judges were got at by the government, and they're not got at by the government in Hong Kong.
We say that statute is binding on the courts. Primary legislation is binding on the courts. But whether that rule is absolute. For example, supposing we had a statute which said that on the instructions of the Prime Minister, any citizen can be imprisoned without trial. What do the courts do with that statute? Would they say the statute is binding?
I recognize the voice and the quality of the question. In one or two cases, senior judges have raised the question of precisely the question that's been raised now. If the government, Parliament, passed a law which was so offensive to all our fundamental principles, would the courts turn round and say, I'm sorry, parliamentary supremacy only goes so far, the courts won't wear this? there was a recent case, fairly recent case, following after I left the Supreme Court, where this was discussed. It was about whether the government could pass a law saying that the courts couldn't consider a decision made by the executive under this law. In other words, cutting out the court's power to review whether the government's decision on a certain type of issue was lawful or not. And there was a difference between the judges, the more conservative judges and the more liberal judges, as to whether or not, if that was what the Act said, the courts could interfere and say, we're not going to give effect to what Parliament has said. And I think the answer to Professor Good's question, to Sir Roy's question, is that we have to wait and see. I was very relieved while I was a judge that that point didn't come up, because it would mean that we had a very, very bad government. And while over the past 10 years there have been some pretty unpleasant statutes or bills which the government has sought to bring into effect but hasn't, there's been nothing quite as bad as the sort of bill that has been described now. I think the get out of jail free card answer is that if you had a government that introduced a law saying the Prime Minister can put people in prison or have them executed at will, we would probably have a government that took no notice of what the court said anyway. But nonetheless, if one was a brave judge, one might well say, and I hope I'd have the guts to say, that this law simply is unacceptable and I'm not prepared to give effect to it. But that would be revolutionary, because it is generally accepted that there is parliamentary supremacy, and if Parliament decides that the Prime Minister should have that power, the traditional view is that the courts would accept it. But I think it would depend how bad the law was. But some judges would be more ready to say, we're not going to give effect to it than others. And I expect you'd see a split court.
Ladies and gentlemen, my name is Lawrence Brass. I'm the chairman of Never Shalom Wahat Al Salam, the British Friends, the charity which I'm honoured to represent. And thank you to David Altras for organising today, and to you, Tal. Ladies and gentlemen, it's been a very challenging couple of years in our beloved village, as you can imagine. I was there only a few months ago in April, and I went into one of the classrooms in the extraordinary primary school in the village. And there were two children sitting in the front row, a boy and a girl, 8, 9 years old, and they were laughing and smiling with each other. I don't know their names. And I remarked to the teacher how well they were getting on together. And the teacher said to me, well, it's all about music. I said, why music? You'll see in a minute, she said. At the end of the lesson, we went off to the music school at the back, when these two children, one of them whose father was a soldier for the IDF in Gaza, and the other, the little girl, her grandparents lived in Khan Yunis in Gaza, and no doubt that very day were being subjected to potential bombs and were certainly hungry. And yet these two children were best of mates. And the reason was, as I discovered, that they went into the music room at the school. The boy was playing the drums, the girl was playing the guitar, and they made music together. And they became friends together. And they weren't tribal. And how they coped with that sort of challenge of one boy's father was a soldier and the girl's grandmother was in Gaza, I can't imagine. But I thought it illustrated to me what Never Shalom is really all about. And the importance for your point of view is that the instruments they were playing were paid for by the British Friends of Never Shalom from the money we raised last year at this lecture. So we do make a difference. See, we as a charity provide the extra items that the school needs. Tal spoke very eloquently about 2 teachers in each classroom. The government, and rightly I think, will only supply 1 teacher. But we say there should be a Hebrew teacher and an Arabic teacher. And we pay for the extra teacher. And in addition, the government will give a textbook in 1 language. We don't think that's right. We think that the textbook should be in Hebrew and Arabic. I've been in the class, I've seen them. On the left-hand side is Arabic, on the right-hand side is Hebrew, so that they learn to respect and understand each other. And it's so important. And again, we of the British Friends paid for the extra teacher for each class, and we paid towards the cost of the books. David, you mentioned there was a fire. There was a fire. There were 2 fires, in fact, a couple of years ago. You said it was the settlers. I'm not sure. And that's the whole point of the village. We're not convinced who it was, because extremists on both sides hate what the village stands for. It could have been Arab extremists, Jewish extremists, but they don't want us to survive. They don't want us to thrive. And what did the British Friends do? Well, we went out last year and we bought them a new security gate. We paid for it ourselves. And we paid for CCTV cameras all around the perimeter so the villagers can live a safe and secure life. And then a few weeks ago, our trustees meeting adopted a suggestion by my distinguished predecessor, Sir Andrew Burns, sitting in the front row, and we decided we were going to have a bursary, which we would pay for, of many thousands of pounds per annum, to bring over to the UK either a village resident or a graduate of the wonderful School for Peace to study in Britain and to help spread the wonderful ethos of the village. And the first recipient of our special bursary, Sama Saleme, is sitting over here today. She's lived, come on. Sama is studying now at SOAS this year, thanks to the money that we raised to be able to support her, and please God, for many more years, lots of people from the village will come over and will benefit from the UK educational system, as you are doing at this moment. So the message that I wanted to give you before we depart tonight is to say that whatever we can raise from the cards which are underneath the chairs, yes? On the chairs, will be used for a specific purpose. To pay for a teacher, to pay for a book, to help security, towards the bursaries that we are granting. And with that money, you can help us and our inspiring village to promote the peaceful and tolerant society which is needed now more than ever, and for which we all yearn so much. Thank you very much.
I think you'll all agree that we've been treated to a really important exposition of the rule of law and the need for the independence of the judiciary in the US, in Israel, and in the UK. It's never been more important than now. You can also see why, as barristers, we miss very much Lord Neuberger, although I should say that in every case I appeared before him, he found against me. But even so, he is what he was described when he received a degree at the University of Oxford in a very technical legal phrase, the mensch on the bench. You can see why in that wonderful lecture. I'd also like to take this opportunity of thanking David Alteras, who's the chairman of our legal group, who carries the work of our group throughout the year, and also the staff, Tal Hammersmith in particular, who have put on this event. But would you join me in giving a warm Never Shalom thank you to our Mensch, Lord Neuberger. Thank you.